I'd like to welcome you to this latest lecture on sovereign and non-sovereign actions and diplomatic immunity, personal and property as a part of the Swayam course on international law. We would first discuss sovereign and non-sovereign actions and then move on to diplomatic immunity. The term sovereign actions refers to actions taken by a sovereign entity, typically a state or government, in the exercise of its authority or power. These actions can include decisions or policies that a government implements in areas like governance, law enforcement, defense, foreign relations, or economic regulation. In a broader sense, sovereign refers to the supreme authority of a state to govern itself without external interference. Therefore, sovereign actions usually imply decisions or activities undertaken by a government that reflect its autonomy and control over its territory, laws, and affairs. Some key examples of sovereign actions might include imposing taxes and signing treaties with other countries. The principle of immunity for sovereign actions, however, has a slightly different meaning and refers to the principle that a sovereign state, such as a country or government, cannot be sued in its own courts or in foreign courts without its consent. This is a fundamental aspect of international law and helps to protect the sovereignty and independence of states. International law generally recognizes the principle of sovereign immunity for actions taken by a state in its official capacity. This includes activities such as the enactment of laws, military actions, and diplomatic relations. Sovereign immunity protects governments from being sued by private individuals or other states without their permission. The idea is that a state is sovereign and therefore not subject to the jurisdiction of other courts, especially when performing governmental functions such as military action or diplomatic activities. This immunity can be absolute or limited depending on the legal framework of the country or international conventions. The concept of absolute immunity would mean that the state cannot be sued for any action, whether governmental or not. On the other hand, many countries have adopted a restrictive approach which limits immunity to actions related to sovereign functions like policy making and diplomacy, but not to commercial or private actions like business dealing or contracts. If a state engages in commercial or private business activities, it may lose its immunity for disputes arising from those activities. It must also be noted here that many countries and international bodies have argued that sovereign immunity should not protect states from lawsuits related to grave human rights violations such as torture, genocide, or war crimes. International courts like the International Criminal Court or ICC have jurisdiction over such matters. Let us now discuss the concepts in detail. Absolute sovereign immunity is a legal doctrine that shields a sovereign state, that is, a government or country, from being sued in both its own courts and foreign courts without its consent for any action it takes, including both governmental and non-governmental activities. Under this principle, a state is immune from legal actions even if those actions are wrongful or violate the rights of individuals or other states. The main idea behind absolute sovereign immunity is that a sovereign state cannot be subjected to the jurisdiction of foreign courts because it is considered equal to other sovereign states in the international system. The principle upholds the sovereignty and independence of states, allowing them to conduct their affairs without fear of being sued or held accountable in foreign jurisdictions. Under absolute immunity, a sovereign state cannot be sued in foreign courts for its actions, regardless of whether those actions are deemed unlawful, improper, or in violation of international law. This immunity covers all actions taken by a state, even those involving acts of war, diplomacy, or policy decisions which are considered to be a part of a state's sovereign functions. These actions cannot be challenged in court even if they cause harm to individuals or other states. In simple terms, there are no exceptions for wrongful acts such as violations of human rights or breaches of commercial contracts. The idea is that any governmental act, regardless of its nature, is immune from legal action. While highly debated today, the principle of absolute immunity was prevalent in the early history of international law, as it was widely believed that no country should be forced to appear in a foreign court because it might undermine its sovereignty and independence. It was originally based on the idea that a sovereign state is equal to other states and no state should be subject to the jurisdiction of other states' courts. This protected the notion of sovereignty by ensuring that foreign courts should not interfere with a state's internal or external affairs. In recent decades, absolute immunity has been criticized because it can prevent individuals or other countries from holding a state accountable for wrongful actions including human rights violations, acts of terrorism, or violations of international law. Over time, many countries, including the United States, have moved towards a more restrictive approach towards sovereign immunity. Under this approach, states are still immune for acts that are governmental in nature, but they may be sued for actions that are commercial or non-sovereign in nature, such as business dealings or breaches of contracts. It is also understood that states can voluntarily waive their immunity in specific cases, typically through treaties or contractual agreements. In the United States, the Foreign Sovereign Immunities Act or FSIA, enacted in 1976, provides the framework for when foreign government can be sued in US courts. The FSIA originally embodied a principle of absolute immunity, but later amendments and case law introduced exceptions allowing foreign states to be sued in US courts under specific conditions, like in cases involving commercial activities or violations of international law. International law also, particularly through the development of human rights norms and institutions, has pushed back against absolute immunity when it comes to violation of fundamental rights. For example, the International Criminal Court or ICC has jurisdiction over certain crimes that states cannot shield through sovereign immunity, such as war crimes, genocide, and crimes against humanity. While absolute sovereign immunity is no longer the dominant approach in modern international law, it remains important in certain contexts. For example, when a foreign government is performing sovereign functions like diplomacy or military operations, it is often still immune from lawsuits. However, when a state engages in commercial transactions or violates international law, the immunity can be challenged in some jurisdictions. The widely accepted theory today is of restrictive sovereign immunity, which is a legal principle that limits the extent to which a sovereign state is immune from being sued in foreign courts. Under this doctrine, a state enjoys immunity for its sovereign acts, like those related to government functions such as policy making, diplomacy, and military actions, but loses immunity when it engages in activities of a commercial or private nature, such as entering into contracts or conducting business. This approach aims to balance the protection of a state's sovereignty with the need for accountability in specific situations. Under restrictive immunity, a state is immune from lawsuits for acts that are clearly part of its sovereign functions, like legislative acts, military actions, or diplomatic actions. However, when a state engages in commercial activities or other private non-sovereign acts, such as business transactions, contracts, or real estate deals, it may lose immunity and be subject to legal action in foreign courts. The basis of restrictive immunity principle is that acts of state could be divided into sovereign acts, that is, acts directly related to governance such as state decisions on foreign policy, military operations, or exercising powers of statehood, and non-sovereign acts such as commercial transactions or actions of a private nature, such as entering into business contracts, engaging in trade, or owning property, which are treated like actions of private individuals or entities. The principle of restrictive sovereign immunity allows for exceptions, particularly when states engage in commercial or private activities. For example, a foreign government might be sued in a domestic court if it enters into a commercial contract with a private entity and fails to fulfill its obligations. A state might also lose its immunity if it violates international law or engages in activities like violating human rights or committing crimes under international law. The shift from absolute to restrictive immunity began in the 20th century as international relations became more complex and states increasingly engaged in commercial activities. The growing importance of international trade, foreign investment, and cross-border legal disputes made it necessary to differentiate between sovereign acts, which should remain immune, and non-sovereign acts, which should not. Many countries, including the United States, the United Kingdom, and members of the European Union, have adopted the restrictive doctrine, incorporating it into domestic law through statutes and court decisions. The principle of restrictive sovereign immunity has many advantages which makes it widely accepted. Restrictive immunity helps ensure that states are accountable for their actions, especially when they engage in commercial activities or violate international norms. By allowing states to be sued for commercial activities, it helps create a level playing field in international business and trade. Lastly, it still preserves the principle of sovereignty by protecting states from interference in their core sovereign functions such as governance, diplomacy, and military actions. It must, however, be noted that while it is widely accepted today, the application of restrictive immunity can be inconsistent and difficult to navigate. Courts often need to determine whether an action is sovereign or non-sovereign, which can be complex. Some critics also argue that restrictive approach undermines diplomatic immunity by potentially exposing governments to lawsuits for activities that are directly related to their diplomatic functions. Moving ahead, now let us look at a concept which is sometimes discussed together with sovereign immunity, which we just mentioned, that is diplomatic immunity. Diplomatic immunity is a legal principle that provides protection to diplomats and other foreign government representatives from certain legal processes in the host country. The idea behind diplomatic immunity is to ensure that diplomats can carry out their duties without fear of harassment, interference, or coercion from the host country's legal system. This immunity is a key part of international law and is enshrined in treaties such as the Vienna Convention on Diplomatic Relations of 1961. Under this principle, diplomats and certain family members are generally immune from the jurisdiction of the courts in the host country. This means they cannot be sued or prosecuted under the host country's laws. However, this immunity only applies to official acts performed in the course of their diplomatic functions. Personal matters that are unrelated to their official duties may not be fully covered. Diplomats are usually exempt from paying local taxes, including income and property taxes, although they may be required to pay taxes in their home country. They are also exempt from certain national legal obligations such as jury duty or local compulsory military service. The embassy or diplomatic mission as well as other diplomatic premises are considered inviolable. This means the host country cannot enter, search or seize property within diplomatic missions without consent from the sending state. The host country is also required to protect diplomatic personnel and property from attack or harm. Family members of diplomats often enjoy similar immunity, but their immunity can be subject to certain limitations depending on their activities and the country's specific legal framework. Similarly, it must be noted here that while diplomats enjoy immunity for actions carried out in their official capacity, they do not have absolute immunity for actions that are purely personal or unrelated to their official work. In some cases, the diplomat's home country may choose to waive immunity and allow the diplomat to be prosecuted or sued for a specific act. Diplomatic immunity is different from sovereign immunity, which applies to states and protects them from being sued in foreign courts. Diplomatic immunity is specifically for individuals and applies to those with a diplomatic status like ambassadors, high commissioners and their staff. The Vienna Convention on Diplomatic Relations of 1961 is the primary international treaty that defines diplomatic immunity. Article 31 of this convention outlines the immunity from criminal jurisdiction, which means that a diplomat cannot be arrested or detained. Article 29 of the same convention provides that the diplomatic agent's person is inviolable. This means that they cannot be subjected to any form of arrest or detention. Article 22 of the convention protects the inviolability of the diplomat's mission, that is embassy or high commission, and ensures that diplomatic agents are not disturbed in their performance of their duties. It must be understood here that diplomatic immunity does not give a diplomat the right to commit any crime without consequence. If a diplomat commits a serious crime such as murder or terrorism, the host country may request the diplomat's home country to waive their immunity, allowing the diplomat to be prosecuted or expelled. In some cases, the diplomat may be expelled, that is declared persona non grata from the host country, which means that they are sent back to their home country. Further, diplomats are not immune for actions unrelated to their official duties such as personal business dealings or private disputes. A branch of diplomatic immunity is the diplomatic immunity of property, which refers to the legal protection granted to the property of diplomats and diplomatic missions such as embassies and consulates from interference, search or seizure by the host country. This immunity ensures that diplomatic property is inviolable and protected from any intrusion by local authorities, safeguarding the integrity of diplomatic functions and maintaining the sovereignty of the sending state's representatives. Under this concept, diplomatic missions such as embassies, consulates and other diplomatic buildings are considered inviolable under international law, particularly under the 1961 Vienna Convention on Diplomatic Relations. Article 22 of the Vienna Convention states that the premises of the mission shall be inviolable. This means that the host country cannot enter the premises without the consent of the sending state, even for law enforcement or judicial purposes. Local authorities have a responsibility to ensure that diplomatic property is not damaged or violated in any way and must take steps to protect it from intrusion, vandalism or destruction. The concept of immunity of property also means that diplomatic property cannot be searched or seized by the host country's authorities. This includes offices, residential buildings, vehicles and other property used for diplomatic purposes. Article 22(3) of the Vienna Convention specifies that the host country cannot allow its authorities or third parties to enter, search or seize the diplomatic premises or property except with the express consent of the sending country. Diplomatic property is immune from local laws and judicial actions. This means that local courts or law enforcement agencies cannot take legal action such as executing a court order, example an eviction or search warrant on diplomatic property without the permission of the sending state. The immunity extends not only to the embassy or consulate itself, but also to diplomatic residences, official vehicles and other property used in the performance of diplomatic functions. Diplomats also enjoy special immunity on communication of messages or bags. Diplomatic bags and pouches which are used to carry official correspondence and documents between the diplomatic mission and the sending state are also immune from search or seizure. The contents of the diplomatic bag cannot be inspected by the host country, ensuring the confidentiality of diplomatic communication. This immunity is protected under Article 27 of the Vienna Convention, which mandates that diplomatic bag shall not be opened or detained. Diplomatic immunity of property ensures the protection and inviolability of diplomatic missions and related property such as embassies, consulates and residences from interference by the host countries. This principle, enshrined in the Vienna Convention on Diplomatic Relations, is critical for enabling diplomats to perform their duties without fear or harassment or intrusion, thereby maintaining smooth and respectful international relations. However, it is not without controversy, as seen from an example in the recent past where Mr. Julian Assange, who was the founder of a website called WikiLeaks, took refuge in the embassy of Ecuador in London, leading to a major diplomatic crisis. With that, we wind up the discussion on sovereign and non-sovereign actions and diplomatic immunity, personal and property. We look forward to meet you in the future lectures.